Okay, now we're going to look at an introduction to criminal liability and also to tort, which is essentially the study of negligence. We're going to examine actus reus, mens rea, and strict liability. This is a really exciting part of law, and one that most people associate with studying the law. It demonstrates clearly how society operates, and of course, it's all about people. Don't worry if these concepts aren't clear straight away. You may have to watch this section a couple of times to really understand these principles of law. Right, off we go. First, we'll examine the application of the concepts of actus reus and mens rea in the context of the following offences: assault, battery, actual bodily harm, wounding, and grievous bodily harm. Actus reus. This includes guilty acts, voluntary acts, omissions, state of affairs cases, and causation, factual and legal. Criminal law deals with offences against society or the state. These offences not only have serious consequences for society in general, but also for the victim and the offender in a particular case. The impact of being found guilty will result in a criminal record and may involve a prison sentence. For these reasons, the burden of proof is high in criminal cases. Where the defendant pleads not guilty, the prosecution must establish its case beyond reasonable doubt. In seeking to prove guilt, the prosecution must, generally speaking, demonstrate a criminal act and a criminal intent by the defendant, and also that these two elements coexisted at the same time. The conduct is the actus reus, and the state of mind is the mens rea. Glanville-Williams has said that a crime requires some external state of affairs that can be categorised as criminal. Simply thinking about committing a crime is not enough. This external state of affairs is sometimes defined as the guilty act, and generally the actus reus involves an action, firing a gun, grabbing a wallet, etc., etc. But, as we shall see, this is not a full definition because in some cases it's a failure to act which makes the defendant liable, or a consequence of an act which leads to liability, or the rare category known as state of affairs cases. In reality, the actus reus covers a number of interconnected factors: conduct, circumstances, and consequences. Sometimes conduct alone is sufficient to establish the offence, e.g. driving without due care and attention does not require the proof of harm to someone else. Such crimes are called conduct crimes. On the other hand, certain forms of conduct may require additional factors to prove that a crime has occurred. Thus, a policeman authorised to carry a licensed firearm is not committing the crime of being in possession of an offensive weapon, even though the conduct involves possessing a gun. What is needed in such cases is conduct plus circumstances, e.g. someone carrying an unlicensed gun on the street outside a bank. The idea behind circumstance is that some forms of conduct can be lawful but become unlawful because of the circumstances. Thus, sexual offences may involve conduct which would be lawful in some circumstances, but becomes unlawful if it takes place in the circumstance of lack of consent. Finally, consequences. Some crimes require an outcome or consequence. For instance, murder requires conduct and the death of the victim, the consequence. Crimes where the end result is crucial are called consequence crimes. To sum up, the actus reus involves the 3 C's: conduct, circumstances, and consequences, which together form the physical elements of a crime.